Good evening, everyone.
Good evening.
Good evening.
Good evening.
Oh, that sounded a little bit more enthusiasm now. It's Monday. All right. Some sound tired, some sound excited. Can't be tired already. It's too early.
Good afternoon.
Hello, hello. So everybody would have gotten their cases, right?
Yeah.
All right,
Yes, I got.
Okay, Cleopatra, you're up first. Colonial Mutual General Insurance versus ANZ. That's a short one. Cleopatra. She was just on just now. Where did she go? Okay, we'll come back to her.
Hello?
Ah, there you are. Colonial Mutual. That's you. Are you ready? You ready, Cleopatra? No? Okay, Mackenzie, you ready?
Sorry, didn't hear you.
Now I said, are you ready? Because Cleopatra didn't answer.
Okay, yes, I could go.
Okay, go ahead. And after you, it could be Janika. Janika do the Court of Appeal.
Okay,
Yeah.
one second. Sorry. Okay. Okay, so my case was between, sorry, screen is freezing. Okay, my case was between Commonwealth Bank, them being the plaintiff, and the defendants, Kendall and Ruby Nottage and Jethro Miller, who were a part of the firm Nottage Miller and Co. And basically, the bank was taking the firm to court because they gave the firm instructions to do a title search on a certain company. Let me start from the beginning. Okay. A specifically endorsed writ of summons was written by the plaintiff, Commonwealth Bank Limited. It was claimed against the defendants. I'm going to say Nottage Miller. Can I say Nottage Miller and Co. instead of saying all the names?
Yeah.
Okay. For damages and negligence of or breach of the fiduciary duty, interest, and cost. The writ of summons stated that the plaintiff is the bank doing business in the Bahamas that carries out lending, and the defendants were the firm and counsel of attorney practicing in Freeport, Grand Bahama. By letter dated the 1st of July, 1995, the bank had asked the defendants to act on their behalf to represent, in respect to the grant of of the bank to the pub of Mall Limited and a guarantee of Silvano's Italian Ice Cream Limited in favor of the bank of debt for the debts of pub on the mall to the bank. The obligations of Silvano's were intended to be secured by a first legal mortgage over Lot 5, East Sunrise Highway, Freeport, owned by them. In acting on behalf of the bank had asked the defendants to advise whether or not the property had good and marketable title, and to ensure that the bank obtained a good and effective mortgage as a security for debts of Silvano's in the event that the bank security needed to be enforced. They were also instructed to inform the bank of any irregularities that would not be favorable to the bank's interest. The defendants well knew in dealing with the bank that by letter dated July 1st, 1995, that the bank would not have not made the loan with the pub mall if they didn't have a guarantee of Silvano's and if they hadn't confirmed that they had good and marketable title. By letter dated the 4th of July, 1995, the defendants confirmed to the bank that the said property was of good and marketable title and that they had prepared the mortgage in favor of the bank as instructed. They also confirmed that the mortgage by Silvano's was intact and that the mortgage was presently held with CIBC, of which would be satisfied out of the loan proceeds and the payment of the closing costs and stamp duty to the defendants. By a letter dated July 6, 1995, the bank settled the defendants' statement of account, inclusive of closing costs and stamp duty fees in the amount of $12,054. The defendants, after the transaction was made, the defendants were fully aware but failed to advise the bank that there was actually no conveyance for the lot to Silvano's. Silvano's had mortgaged the said property to another company, Lowen Mill Company Limited, by debenture dated the 26th of August, 1994, which was recorded in the Registry of Records on the 28th of April, 1995. And that the said mortgage, I have the same issue as Janine. Sorry, my screen is freezing. And that the said mortgage had priority over the mortgage granted to Silvano's in favor of Commonwealth Bank. They also had contemplated that the lot would be conveyed to the pub mall and not Silvano's. In reliance upon the advice given by the defendants in the letter of the 4th of July, 1995, the bank loaned the money to pub of mall and accepted the guarantee of Silvano's of the debts present and future owed by the pub mall limited. On the 7th of October, 1995, the bank agreed to lend more money to pub on the mall by a letter dated the 12th of October, 1999, they also requested that the defendants prepare a supplemental mortgage for additional security over the property. The defendants prepared a supplemental mortgage by pub on the mall and falsely charged the said property as security for the said loan, which the defendants previously advised the bank was owned by Silvano's. Both parties failed to repay the loan, and now the bank wanted to exercise a power of sale either by mortgage granted to Silvano's in July 1995 or supplemental mortgage by pub on the mall in October of 1999. However, as stated earlier, the bank eventually found out on the 24th of August, 2004, that the property was never conveyed to Silvano's or pub on the mall. and that there was an existing mortgage in favor of Lowen Mill. Though the bank relied on the defendant's title search, this information was never disclosed to the bank. Had it been disclosed, the transaction would have never taken place. Pub on the Mall and Sylvanos, but its guaranteed by its guarantee, owed Commonwealth Bank $292,843.77 principal and $2,134.15 in interest as at the 19th of April, 2005. Unfortunately, due to the negligence of the firm, this was a loss to the bank because there was no conveyance to neither Sylvanos or the Pub Mall, and the amount due owed by Sylvanos to Lowen Mill exceeded the value of the said property. The plaintiff now wants to claim for damages interest thereon pursuant of the Civil Procedure Award of Interest Act, costs and such further relief as deemed just. The firm in their defense filed on the 16th of June, 2005, as amended on the 17th of June, 2005, as follows. They admitted to receiving instructions from the bank to prepare a mortgage by Pub Mall Limited, but denied receiving instruction to include guarantee from Sylvanos, and that such a guarantee should have come from Mr. Silvano Bruti only, which was the principal of Sylvanos Limited. They further denied that Sylvanos was ever privy or party to the transaction and stated that if Pub Mall was already indebted to the bank by the 1st of July, 1995, certifying that Sylvanos' title was good and marketable, that this would not be a sole basis of the loan. The defendants also admitted that only during the investigation of title, they were made aware of the fee simple to the entirety of the said property had recently been conveyed to Sylvanos, which had erected an ice cream factory on the same property as Pub of the Mall Limited. It was being contended by the principal owner that the interests of the two companies were separate. The defendants said that they advised the bank that the mortgage had to come from Sylvanos, which by then held the title to the said property. Further, the firm advised the bank that the conveyance was actually from Freeport Commercial and Industrial Limited to Sylvanos. The conveyance also in possession of the firm, possession of the firm the date of the transaction by the bank. They claimed that the conveyance of Lowen Mill, which was never intended to be recorded, was mysteriously taken out of their office, supposedly for safekeeping, and never returned. The conveyance to Sylvanos seemed to be taken as well, but the registry could not produce recording details. Mr. Sylvan Bruti, the principal owned by Sylvanos, the principal owner of Sylvanos, contended that Sylvanos had nothing to do with the Pub of Law's liability to the bank, but Pub on the Mall historically occupied the land under a 99-year lease, of which was surrendered so the fee simple could be conveyed to Sylvanos. But Sylvanos, of which the bank had no interest, and the pub of which the security of CIBC was occupied by the same property. They also stated that according to Mr. Bruti, the statement made by the bank that the loan was delinquent was false. The defendants alleged that it seemed to be a dispute between Mr. Bruti and Mr. Wells, who previously was an account officer at CIBC and presently was account officer or agent of this account with Commonwealth Bank. They also stated that the said property had an actual value of in excess to $4 million. They also denied that the plaintiff suffered any loss as the mortgage was not in default and that as far as they knew, the bank took out no steps to enforce their security. On 14th of July 2005, the bank sought to strike out the defendant's amendment defense pursuant of the rules of the Supreme Court Order 18, Rule 19, and also the inherent jurisdiction of the court as disclosing no reasonable course of action. This order, you can find it on page 6. I think this order came up again in the last case I had as well, but it's on page 6, paragraph 8 and 9. The application was set down for hearing, but later adjourned by request of the council. The matter was dormant for a while and the bank decided to proceed by notice filed 14th of November 2013. Another summons was filed by the bank on the 30th of July 2014 to renew their application. The plaintiff relied on the affidavit of Walter Wells, filed August 26, 2005, and Aisha Stuart Smith filed 23rd of October 2014, as well as documented evidence. The most important claim of the plaintiff was that the defendant acted negligently and or were in breach of the fiduciary duty to the plaintiff in giving the advice contained in their letter dated the 4th of July, 1995 and the 22nd of October, 1999, when they knew or should have known that same was inaccurate, resulting in an advancement of funds to Pub Mall, of which the bank cannot recover, and the plaintiff's security being defective, leaving the bank unable to enforce same. To support the claim, the bank provided their letters of instruction, which outlined the defendant's obligations and acknowledgement of same. They also provided evidence that the conveyance was never recorded despite the defendants falsely confirming that the title was intact. In opposition of the plaintiff's claim, the defendants relied on the affidavit of Silvano Brudi, filed on the 11th of December 2014, of which he restates what was said in the statement of claim. And boy, there's a lot, I guess. And after all the back and forth with the court finally decided that because the chief complaint really was that the firm was negligent in their duties to the bank. The bank was at a loss because they basically could not recover the monies that was owed. And also they couldn't, the bank security was defective. And I know, Ms. Archer, help me out there. And
Well, don't forget now, the notages said that their defense more or less was saying that they weren't obligated to disclose the debenture.
right.
That was their main,
Yeah.
which really doesn't make any sense. Because
Right.
if you guarantor and the guarantor is providing his own property, wouldn't you have to register that?
Yes, you would.
That's what, yeah, right. If a legal demand mortgage, he's using that as a guarantee, it has to be registered. So they were negligent in terms of not advising the bank that there was already a lien on that property. I don't understand how they did that.
Yeah.
Question.
I
So
don't understand how.
what
sorry,
was the book transaction? Because the book, they were saying that the facility with the loan company was supposed to be just a book transaction and not something that was supposed to have been registered and recorded. and it got registered and recorded, they do not know how, because it was taken without their permission out of their office, and they didn't know when that had happened and how it had happened.
And when she read it just now, I'm trying to figure out what you mean. What do they mean? They don't know when it happened, how it happened.
They were saying that it was taken out of the office without permission when neither of them were in office.
I get
So
that.
they, in effect, they couldn't find the documents
But
because they
how
were
could they
actually
have
not there.
access? How could they have access to documents in their office? Someone had to give them it.
Exactly. Those things are on the
Ugh.
locking.
So it would seem as though when it was taken out, they never thought, when they missed it, they never thought to check the registrar's office, because they know they didn't register and record it, but they never checked. And someone had lodged it to be registered and recorded.
Right. So do you think someone from Low and Mill had called and asked, has it been registered? And someone from the office went and registered it?
Yes,
They could have, because I think they also said, okay, they were saying, okay, it was mysteriously taken, but not mysteriously, obviously,
Oh.
but then they said for safekeeping and never returned. That's the part I'm lost on. Why for
Yeah.
safekeeping? So someone just took it just to say they wanted to have it, as if they just was keeping it?
No, but why would the lawyer give the documents for safekeeping?
That part I lost on, I don't know.
So even when they sent it for safekeeping, they're still negligent because being the
Yes.
lawyer, they realized that it had to be registered.
they still never checked to see that it was registered and recorded.
Right, because they thought that it didn't have to be registered. That's what they're thinking. It didn't have to be registered. So their whole thought process at the very beginning of the transaction was flawed.
Yeah.
But if you look at it, I would think that somehow they were trying to default the bank in any event, because you have an in-house mortgage with the loan company that is, yes, supposed to be a book transaction, but you're here acting on behalf of the bank to put a first demand legal mortgage over the same property. So
Yeah.
it seems as though you're trying to defraud someone.
Yeah. But you know, these people don't take this definition of fraud seriously.
No,
No, to them, that's not fraud.
no.
No, seriously. A lot of things that you see happen when you read these things, you could just get on the top now. You sit back clearly, you could say this is fraud. Someone had an ulterior motive. Someone was trying to hide or do something to circumvent something.
Yeah.
Yes,
But the bottom line is just so I could get my fees. I just want to be paid.
right.
The likelihood of someone figuring out what this is slim. And that's the premise that they work upon.
Right, because they were supposed to have those documents in their possession.
Exactly.
The person who was actually supposed to be defrauded, I feel like would have been the loan company. But they, in turn, when they got those documents for safekeeping, they in turn knew that there had to be another process. This have to be registered and recorded, or I don't have any security.
Exactly.
So they did what they had to do, and it appears that they went with another firm to do that registration and recording.
See, because it says in paragraph 43, the judge said, it is in my judgment no defense to the plaintiff's claim that the document, although fully executed, was not to be perfected or registered on force, or that it was stolen from the defendant's office and stamped and
Right.
recorded the knowledge consent, or the knowledge or consent of the plaintiff's borrower, the pub on the mall limited, or Sylvanas or Mr. Broody. It doesn't make any sense, especially if you're talking about a mortgage.
Mhm.
And if I'm the guarantor and I'm putting up my property, then how is the bank going to get that first legal demand over that property if it's not registered?
Right. So they did what they had to do. Um,
Yeah, it's sad. But
so
unless
what
you
recourse then the bank has then? None? I would think they would sue the law firm then for their funds.
you mean the bank,
Yeah.
Yes.
so the bank is suing
Yeah, they suing them.
they're suing them. They are suing them.
It
And
seems
that's
to have gone on for a very, very
Yeah.
long time.
So the judge said, the defendants ought to have discovered it on a proper search, the registry of
Mhm.
records. And they're saying that the lawyers had another opportunity in 1999, that's 4 years later, to discover the debenture, notify the bank, but it failed to do so.
Right.
And again, they're saying that opined that the bank's loans to the pub on the mall was secured. So how could it be secured if you didn't
With
register it?
nothing.
Yeah.
So it's obvious negligence.
Mm-hmm.
To tell you that. How can you say something is secured if it's not registered?
Yep.
It doesn't make any sense. Okay, Janique, let's hear what the notages say when they appealed. Because you know they were going to appeal.
Okay. This is the right case. Kendall W. Nottage and Ruby Nottage and Jethro Miller.
Uh-huh.
They were the appellants, and this is with Commonwealth Bank.
Yep.
Against Commonwealth Bank, who were the respondents.
Mm.
Now, the gist of what I'm getting, and you just correct me if I go off. They actually didn't get as far as the appeals. What actually happened, they applied, they were going forward with appealing, but they made a request in May 2016, they sought a leave to appeal out of time because, the decision of Justice Gray Evans to strike out the appellant's defense. So what actually happened, they were requesting an extension for them to apply. Correct me if I'm wrong, please, for the appeal. And in their request, they had a time frame to have their requests submitted. And it appears that according to Jethro Miller, he was one of the appellants. He submitted his request and it wasn't received until days later. So he had, okay, I think I'm a little bit ahead, right? He
Yeah.
had missed, okay, let me backtrack then. Okay, after their request was to request an extension for the appeal. Defendant, they got a date to appeal, which was May 2016. And for some reason, only the respondent's attorney appeared. The appellant didn't. So the matter was dismissed. For some strange reason, the matter appeared on the court register or with a date for another hearing for this appeal in June. Now, the judge, they didn't know why it appeared, but they didn't push it, but it appeared. And for that hearing in June, nobody showed up. That was also dismissed. The appellant now comes ahead, is seeking restoration for the dismissed application. So really and truly 2 dates were missed. And they were supposedly seeking an extension for the appeal deadline, if I'm correct, because they felt that they needed more time to get more information or documentation together. So the case of British Mensa Limited versus Gallatin 1999 is used as a case matter, and it appeared that certain factors pertinent to the extension of time application are also of some relevance to the application to reinstate an application for an extension. I repeated that, of time within which to appeal. Okay, the reason for the delay or dismissal, the prospect of success of the appeal and any pertinent prejudice to the respondent is more or less necessary. So the gist of the attendant's appellant defense appears to be that the person unknown had improperly removed the debenture in favor of Lowen Mill from the firm, which was not intended to be perfected or registered. And it is unclear what consequences arose due to the registration. So that the respondent, his just more or less was, but there was no discernible prejudice to the respondent, has been disclosed beyond the delay in achieving closure in their case and securing the fruits of their victory. Again, the premises, the latest application by the intended appellant ought to be dismissed because of the following reasons. The reason for the delay in appealing Evans J's decision was not clear. The chances of success, they need to prove that. And the reason not appearing at the hearing of the application. So this is what the appellant needed to more or less soothe or present to say, they have a reason for it. Now in the judgment side of it, the appellant, he made notice that he wanted to restore their application to extend the time of the dismissed application on May, which he did not attend. And he wanted also, this was also to assist with him being able to strike out on 29, striking out the appellant's, let me backtrack, sorry. Okay, he wanted to strike out Justice Evans Gray's decision. So the extension was needed in order for him to do that. So he wanted that application opened up again so he could have this extension. The appellant, the issue also with the appellant, but I started to say, was to do with time. One matter that came up was that, yes, he made an application to leave, but the time he filed it, there was an issue with the date that it was done. It was filed on the 31st of March, and the application was dismissed on the 17th. There was, for some reason, I think he said something about he sent it and it wasn't delivered till a week later or something. So he was using that as part of the issue. And he also stated that he made contact. He was in contact with his attorney, and the attorney never said to him about the date. And because I don't think he was on the island or something of that nature, he did not know of the date. He really found out about it when the respondent's attorney more or less made fun of it, the fact that, hey, he contacted him and he said, we won our case, it was dismissed. So you have no more appeal, more or less. So he said that was the first time he knew about it. And you can help me if I off, please.
No, go ahead.
Okay.
Go ahead.
And also the other issue was, for some reason, it appeared on the calendar, but it was dismissed again because nobody was there. So both instances, it was dismissed, and the appellant, according to him, knew nothing of it. A requirement, okay, the registry of record, but the issue also arose that both matters were noted on the register for the court. So he more or less, it was more or less his responsibility or his attorney to ensure that they got the date. So what was said also was that at least 7 days before the first day of each month, the registrar shall cause to be posted on the notice board of the court and the official website of the court. So both dates were noted, and his attorney should have known, or he should have been watching or to find out what was wrong. So that was a issue where they were, it was against him because he didn't get the date. So there was nobody's fault to some degree than his own and his attorney. The intended appellant, okay, presents. Okay, I got that part. Okay, the first matter. Okay, the court matter that must be resolved in whether the court has a jurisdiction. So the question was, does the court have the jurisdiction to reinstate an application of such? And Rule 31 of the Court Appeal provides for this. It says that if an appellant fails to appear when the appeal is called on for hearing, the appeal may be struck out or dismissed with or without cause. When an appeal has been struck out or dismissed owing to non-appearance of the appellant, the court may, on application by the appellant, by notice or motion, supported by an affidavit if it thinks fit, and on such terms as the cost or otherwise as it may deem just, direct the appeal to be re-entered for hearing. An application for re-entry of the appeal under this rule shall be made within 21 days from the date of the judgment or order set to be set aside, sought to be set aside. However, this was not an appeal. So this is where a judgment call had to be made, but an application for an extension to extend the time limited for appealing. So there was no specific provision for such an eventuality. This then recourse of Section 9 of the Court of Appeal rules. And the Court of Appeal rule states that where in any case, no special provision is contained in this or any other act or in rules of the court with reference thereto, or any jurisdiction in relation to the appeals in criminal or civil matters shall be exercised by the court as may be in conformity with the law and practice of time being observed in England by the Court of Criminal Appeal and Court of Appeal respectively. So the court had to make a judgment call on this. And the Court of Appeal jurisdiction. Okay. The Court of Appeal, what actually happens? The court, trying to cut it down. The Court of Appeal one minute. Okay, Mr. Jethro filed an affidavit on June 15 to support his application to restore the leave. And his, this was outlined that following the filing of 2 successive visits, okay, I summed this up already. It's part where he made contact and he more or less is saying it's not his fault. He attempted and he tried to get the date, which he didn't. Mr. Edward Thomas, and this is where he said he didn't know about it until the attorney of the respondent more or less called him and threw it in his face that, hey, we won the case. And he also said that if the counsel with care of any matter is simply not present when the matter is called or instinct. So he's saying there should have been, someone should have called him a courtesy call because there was no reason why he would not have shown up. Myself and Mr. Marshall, and several other attorneys in this firm communication, they're constantly in contact. So he couldn't understand why he didn't receive a call to say This is part of his reason for not being there. So he is using this to say he has a good reason, so they should reinstate his request. And he also said that the council is well aware that the matter involves my firm. So he has a personal involvement, which would have prevented that he would definitely have been there because it was important to him. And accordingly, he is now requesting another extension. It would be another extension because he didn't show up to the other two requests. Mr. Miller submitted an affidavit that he does not take responsibility for failure to appear. And he also stated that the matter was done ex parte, that the respondent through its counsel, Mr. Edward Marshall, appeared at the appointed time. So the decision more or less was made without him being able to give his input. The factors are an appeal in the form.
Now remember now, for him to do this appeal and for the court to hear him, he had to do it on the basis of the prospect of success.
Right. And his reasoning for success was that he felt that, well, if he had more time to get his information together, his things together, he would have been able to defend himself better. There was a bias he felt that was a part of it, that the judge, the trial judge was a part of a law firm that represented, the fact that the trial judge was a member of a firm, the law firm that represented the pub on the mall. So he felt that there was a bias also involved in that, and that the judge erred in coming to the conclusion, conducting the trial to the final determination of the matter with not having all the evidence. And this is what he wanted to get. The trial judge also not having all the evidence not being presented, he felt that she either had some information on the side that wasn't presented at the case, because for her to come to a conclusion, she needed some additional information. So possibly something that she knew wasn't presented in court. Also, the debenture came up again because it should not have been done. It should not have been recorded, and it was. And he also stated that even there was someone offered to do a subrogation, and there was a subrogation to sell the matter, and there was an intervention that caused it not to go through. So that was another issue. And the pub was still making payments, and it was unfair that they were still collecting on this loan or debt or whatever it was. So the pub was still making payments. And did I get everything in full or not?
Yeah, I'll go down now to paragraph 16, where the judge is saying, even though he filed all of these affidavits pleading out of time, what did he say the issue is? The issue is what? That they allege that the debenture just miraculously just disappeared.
Right, okay. And it's unclear with the registration of this debenture. And there was no discernible prejudice. When it comes to the respondent, there was no, I said that earlier. It is unclear defense appears to have been that a person properly removed the debenture in favor of the Lowell Company from the office, which was not intended to be completed or perfected and registered.
Mhm.
It is
And-
unclear what the consequences arose due to this registration, so he wasn't able to prove in this regard, the whole situation with this being registered. Further, as I am not, this is the judge, I have not had sight of Evan J's decision, so he also didn't provide the appellant judge with all the information. There is no context for the paragraph references made to the intended notice. It was not exhibited in the extended appellant's affidavit, so he didn't put what was required or what the judge needed to make a decision in his affidavit. And another thing was too, I think I missed a part, that he was saying also the appellant, that because of the time frame, it was such a long period that they were working with affidavits. So the information may have been miscrewed or left out because the period involved was so long, it didn't work out favorable for him in the case.
Mhm. Yeah,
I know I'm all over the place, right?
yeah,
It
he did. Next, you'll get better. You're getting
Okay, it was not exhibited. This is what the judge was saying, the appeal court's judge. It was not exhibited to the extent, to the intended applicants, the appellant's affidavit in support of the application to extend the time for appealing, or the affidavit in support of the application to restore the application for extended time. Consequently, the court is at loss as a defense of the intended appellant. So at the end of it, the judge said that I am of the view that the latest application by the intended appellant ought to be dismissed because it fails to adequately explain the reason for the delay in appealing Evan J's decision, the chances of success, and the reason for not appearing at the hearing of their application. In this premises, the appeal, the case was dismissed.
That's right. Any comments? So you see, there's always recourse to the Court of Appeal, but you have to present your case properly. Dorame, you were going to say something?
Yeah, I just was gonna say he was a sloppy lawyer from the break. If he wasn't trying to sue people, then maybe he would have had it together, but he never had it together from jump.
Yeah, and listen, and you knew this matter was being heard, so why weren't you being attentive?
And if it was so much of a, close to heart situation, why would you not go to try and get it sorted out so you don't look like a fraudster? Like you just didn't go. So obviously you had bad intentions from the beginning.
That was flimsy,
Yeah.
very, very flimsy. All right, and who read Supreme Court, Bank of the Bahamas and Mark Gibson? Another tricky one. Don't say nobody read it. Just because I didn't assign.
I read it.
Okay. So, tell me about Mr. Mark Gibson.
That's the one Dimitri's supposed to do.
Oh, Dimitri is supposed to do the Court of Appeal.
Okay, goodbye.
Alicia, you want to do it? It's very short.
I didn't read it, ma'am, in all honesty.
You didn't read it. Oh, Lord. All right. So in this case, Mr. Gibson, Mark Gibson is being sued by the Bank of the Bahamas. So he was an existing customer of the bank, and he went to the bank and he got an additional commercial loan in the amount of $80,000 in November 2006.
That's the one I read, Miss Archer.
That's the one you read?
Yeah, that ain't the
Okay.
one I supposed to present.
You're supposed to do the one for the Court of Appeal. Go ahead.
Demetria do the wrong one then.
No, go ahead then if you did it.
So
You did the one with
with whom?
5 pages.
This the one with 6 pages, yeah.
Yeah,
5 to
okay.
6 pages. Yeah, he got an additional loan for 80,000. That was in November of 2006. According to the new commitment letter, that brought his total indebtedness to the bank up for over 300,000. And the 2 loans required payments, I guess, totaling $2,700. And they were secured by a first-demand mortgage over the properties for Mr. Gibson. Now, he got these facilities in May of 2009. They agreed to the restructuring of the facilities. And I guess earlier, he did not reflect, I guess, timely payments. So the bank, I guess the bank's representative, because who was that? Jamal Davis, he appeared on behalf of the bank, and then Mr. Gibson decided to represent himself. They were able to provide exhibits or documents showing where he had missing payments, or showing where he actually missed payments. And they were stated in there, well, they had in their introductory paragraph of December of 2009 for that, for the economic circumstances under the loan, why they would have restructured it and what they would have lent Mr. Gibson. So the bank in itself stated that the weakness in local economic conditions precipitated by the global recession has created a certain degree of financial disharmony amongst families and individuals across almost all business sectors. As a result of this, the bank is seeking to provide our customers with financial relief based on individual circumstances. So based on his request, he would have fallen under that, and they agreed to restructure it. He got that restructure, and it showed a new figure, and that new figure would have been 305,000 over a 20-year period, and it was to mature May 2029. And the consolidated amount slightly decreased from the 27 to the 2558 monthly. In December of 2011, the bank alleged that Mr. Gibson had been in arrears of the loan, and they commenced action against him. And they were seeking, I guess, relief in a total of 295,000, interest on the sum at the date of judgment, and costs. So all of this is the same thing. Based on their summary judgment and what they would have filed, according to Mr. Davis, and an affidavit from Mr. Davis and Mr. Anton Higgs and Paulette Butterfield, Mr. Gibson filed a counterclaim and summons seeking to strike out the summary judgment application of the bank. And he was relying on affidavit to support his case. That he had dated, I guess, in 2012, 2019, 2020, and 2020. Oh, January 2020 and 16th of January 2020. And he also got an accountant to go over, I guess, his mortgage statements, and he used that in his defense. So the bank said that Mr. Gibson did not have sufficient funds on his account to satisfy his payments for the months highlighted, which was October of 2009, January to March of 2010, which August of 2010, October to December of 2010, May 2011, and August 2011. He admitted to not having paid anything on the loan facility since 2016 in his affidavit. And he asked that he be permitted to do so or to clear out the total of $286,000 within 240 days. The bank, Gibson filed a defense and counterclaim alleged Gibson, who filed a counterclaim, he said he was not in default of his payments under the loan facility, and he relied on his accountant statements, which identified principal disbursements up to the 4th of September of 2009. So he's stating that because his loan wasn't fully dispersed until September of 2009, he should not have been making payments until the following month, which was 30 days thereafter, being October 2009. However, when he got the mortgage, it was payments were just, I think the $80,000 was an additional amount that was added on to the existing mortgage. So payments were continuing. And he was not making those payments. So he's stating that because the bank is saying that when they did the transaction in May, his payment should have continued on from June. And he's claiming that that's not correct. He would not be in default if they would have the final disbursement would have been done in September. So he would have been making payments since October. However, given that, based on the analysis of the account, it was discovered that when they did the calculations, even if his payments were to begin in October, which wasn't accepted by the bank, by his own account, Gibson was still short. His payments were still short because he would have had to have accumulated 23 payments of that 2558 monthly, which would have totaled $58,000. And when they would have reviewed his accountant's statement on page 4, Gibson only had paid $56,000 up to August of 2011. So if the payments ought to have commenced in June of 2009, Gibson ought to have paid $67,000. So his payments therefore still fell short, or far short. So having considered the matter, the judge was satisfied that the bank had made out the case for summary judgment, and Gibson was clearly in default of the loan facilities and did not have a real defense to the claim, save maybe as to the amount ultimately due to the bank. So it would have been more, I guess what he's saying is based on what the bank is saying, $295, and Gibson is saying $286. That's the only thing that, would have been more of a dispute as to the amount that was owed. But when it comes to repayment, he obviously was in default. Further, in light of Gibson's admission that he had not paid the loan facility since 2016, the judge gave summary judgment for the bank for breach of the mortgage loan facility with damages to be assessed by the registrar.
You didn't read the one for the Court of Appeal?
No, ma'am. No, ma'am. No, ma'am. I don't know how I missed that one.
Right. So, of course, Mr. Gibson appealed.
Mr.
Of course he appealed.
Well,
You did.
I guess not.
Yes,
I guess why not?
Why not? All right. So he
Why not?
appealed. And the judge took into consideration Order 14, Rule 5. which speaks to the test to be applied by the court is
Uh-huh.
whether tribal issue or question, or whether for some other reason there ought to be a trial. So don't forget now, when you're appealing, the question then is whether or not a trial needs to be heard. So if a plaintiff application is properly constituted and there is no tribal issue or question, nor any other reason why there ought to be a trial, the court may give summary judgment for the plaintiff. So it is a well-established principle of law that the court ought to be cautious, since it is a serious step to give summary judgment. Nonetheless, a plaintiff is entitled to summary judgment if the defendant does not have a good or viable defense to his claim. And this is also key in keeping in with the overriding objective of Order 31A, to deal with cases justly by saving unnecessary expense and ensuring timely and expeditious disposal of cases. It is also part of the court's active case management role to ascertain the issues at an early stage and to decide what issues need full investigation at trial and to dispose summarily of the others. And so, of course, he is appealing. So it says in the present case, Winder J found that was the judge at the Supreme Court level that you just read, found that Mr. Gibson was clearly in default of the loan facilities, and he didn't have a real defense to the claim, save maybe as to the amount ultimately due to the bank. Because remember now, he was disputing it. The short answer to this, right, the short answer to this matter is that the judgment of Judge Winder notes that Gibson admits to not having paid anything on the loan facility since 2016. In his 16th of January 2020 affidavit to the Court of Appeal, he asks that he be permitted to pay the sum he says is due, $286,113.17 within 240 days. And to this extent, he accepts being indebted to the bank and obligated to pay at least $286,113.17. That's what he agreed to in the Supreme Court, right?
Yeah,
286.
286.
Right. So the bank's position as to Mr. Gibson's indebtedness is set out in the affidavit of Mr. Higgs, and that was filed on the 6th of September 2019. And in that he said that I verily believe that the amount of the defendant's present indebtedness to the bank under the loan account is $487,783.54, being $317,422.38 as to the principal sum, $167,281.16 as to the interest sum, and $3,080 as to late fees. And that's as of the 18th of July, 2019. That his last payment thereunder was on the 6th of June, 2016. And that his arrears thereunder is presently $286,776.34. And of course, he produced the exhibit to demonstrate those figures. Says, a true copy of the loan account and the defendant's current account with the plaintiff bearing account number, whatever, both of the said 18th day of July, 2019. So in his submissions before the court, Mr. Gibson contended that during the hearing of the application before Judge Winder, the respondent conceded that all that was due and owing to them was the sum of $286,113.17. Is that correct? Is that what the bank said? That was all owing to them, $286,113.17?
No, that's what Mr. Gibson said. The bank was going for the sum of $295,713.
Right. So he submitted that in those circumstances, the learned judge should have made an order to that effect. The appellant in his second affidavit filed on the 16th of January 2020 in support of his application to dismiss and strike out the respondent's application stated as follows: that the defendant maintains that he is only owing to the plaintiffs 286,113.17 as at the 30th of July 2012. This is the correct amount calculated by CPA found in exhibit label LM1. Remember, that's MACOC. That the defendant humbly asks the court to grant permission to repay the plaintiff the amount of 286,113.17 in one disbursement on or before 240 days of final judgment. So now he running the bank. Look, who says the bank just wants what's in arrears?
No, it's the principal sum plus interest.
Exactly, you have to pay all. So the appellant relied on an exchange between the trial judge and counsel for the respondent, which is seen in an extract from the transcript as follows. The court, Mr. Davis, case number 1693 of 2011. Mr. Mark Gibson appearing in person. The court, you were here last on the 15th? Mr. Davis, yes, my lord. The court, I received some documents from Mr. Gibson on the 16th. Mr. Davis, yes, I got that as well. The court, do you have any issues with it? Mr. Davis, no, my lord, except to say that I see from paragraph 18 that there is an admission of at least the sum of 286,000 as from 2012, and I request to pay that amount. It is clear that the trial judge did not construe Mr. Davis's comments as an agreement to compromise the action for the sum of 286,113.17. In my view, he was correct not to do so, as what was said could not, without more, constitute a compromise of the action. I should note that the appellant's other point of contention was that when the demand was made and the action filed, he was not in arrears. He based this submission on his view that BOB was using the wrong commencement date for the loan payments, remember? He said it wasn't May, it should have been October.
Yes.
It is unfortunate that the commitment letter did not have a commencement date. The appellant submitted that in those circumstances, as the agreement provided that, quote, all other existing terms and conditions outlined in the original loan agreement remain unchanged, end quote, the 2006 agreement would govern the commencement date. In my view, the learned judge rightly rejected that submission. The 2009 agreement clearly stated that the loan would run for 347 months and expire on the new maturity date, the 30th of May, 2029. In these circumstances, it was clear that the commencement date would have to be June 2009. It is clear that there was a dispute as to whether Gibson was in arrears when the demand was issued. However, as noted by Judge Winder, in light of the appellant's admission that he had not paid the loan facility since 2016, the only real issue to be determined by the court was the true amount owing to the bank. So he says here in paragraph 37, I should note that it is a cause for concern that a dispute between the parties, which had its genesis over a difference of what may have been around $5,000, resulted in an action for a claim for the sum of 295,713.92. However, what is of greater concern is that the action, which was filed on the 9th of December 2011, is still before the courts unresolved, and that claim has now grown to $487,783.54. And of course, Mr. Gibson lost. So if he had paid that,
He have to pay back the 487,000.
yes, ma'am, including costs.
He should have walked with that too. That 295 long time.
Yeah. Because remember in the Supreme Court, that matter was filed from 2011.
Yeah.
And this appeal is done in 2020. Yeah.
It's almost 10 years.
Yep. And he had to pay $500,000. And at that time, he was willing to pay two. He should have deposited his 285 and started to pay the rest.
Yeah.
Now he's paying almost double. It's sad. Real sad. So you see how litigious these mortgages become, especially when mistakes are made and mortgages are in arrears. It gets really technical. And that's why, as bankers, you have to make sure that these mortgages, at least the repayments, are done correctly and that there are no errors. Because when you go to the court, the judge meticulously looks at the transactions and it has to make sense. And you will see where in the cases for next week, you will see where the mortgagor will challenge the figures presented by the mortgagee. So I have two more presenters. Are they ready? Before I go to the
Yes,
chapters?
ma'am.
All right, let's
Yes,
go.
ma'am. Okay, can you hear me?
Yeah.
Okay, the Colonial Mutual General Insurance Company Limited is the appellant. ANZ Banking Group New Zealand Limited is the respondent. And this is from the Court of Appeal of New Zealand. And this is what delivered 27th of June, 1995. This appeal concerns an entitlement of a second mortgage to the proceeds of a fire insurance policy taken out by the mortgagor upon the mortgage property. ANC Banking Group held a second mortgage over a house belonging to Mr. and Mrs. Whitehall. The first mortgage was a company administered by their solicitors, which had procured them an advance of $25,000 from another client. Now, the mortgagor in the documents, it had said they would insure, and as long as any money remains owing on the security, they will keep insured against loss or damage by fire all buildings and erections for the time being situated on the land described in the mortgage, and the insurance to be effected in the name of the mortgagee and in some insurance office in that jurisdiction. Now, what ended up happening was that it expired, and Mr. Whitehall, it was the memorandum of mortgage was executed by the Whitehalls in October 86. And it expired at some point after that. But Mr. Whitehall, when it expired, he got an insurance in his name. And he produced a copy to the bank, a certificate of insurance from CMG, which is the Colonial Mutual General Insurance Company. He provided that the bank a certificate of insurance, and under the heading other parties interested in the insurance, and it was referring only to the first mortgage. So on the 30th of September 87, the bank wrote the insurance company a letter addressing the property and letting them know that they had an interest as a second mortgagee over the property covered by the above policy, and they would appreciate their interest being noted in their records. And so there was produced a new certificate on December 87, which was sent to the bank. And it said under the heading, other parties interested in the insurance, the bank appeared as second mortgagee. Now, on the following year, February 1988, the house was destroyed by fire. In April of that year, 88, the first mortgagees exercised their power of sale, repaid themselves out of the proceeds, and handed over the balance, some 15,000, to the bank. This left the bank with a shortfall of about 73,000 secured by the second mortgage. So it claimed the proceeds of the insurance policy. It had written to the insurance company after the fire to register their claim under the policy in their capacity as the second mortgagee. And on May 10th, 88, the bank made a formal claim for the full amount of the insurance cover. But Mr. Whitehall claimed he was entitled to be paid the money instead. And it was saying here that he seemed to have been very persuasive because the insurance company paid him the balance of 53,000 in full and final settlement. So in these proceedings, the bank claims that it was entitled to the policy and that the insurance company had not been discharged by its payment to Mr. Whitehall because it should have come to the bank. So they gave notice of this assignment, and they were looking at the insurance company for the bank's interest. And the Court of Appeal approached the matter as an assignment of the proceeds of the insurance policy rather than an interest in the policy, but agreed that Clause 5 had effected such assignment and that the insurance company had been given notice. So the insurance company said that yes, it sound good, but the intention of the Clause 5 was to give the bank an interest in the insurance policy, and it did not operate as an assignment. So they were arguing over whether they should pay the bank. And they're saying in the fourth schedule to the Property Law Act, in the name of the mortgagee, it showed that the bank was to obtain its interest as the original insured on behalf of whom the mortgagor took out the policy. And there was arguing back and forth as to who had the interest in the policy, and the mortgagor having his own name on it. And the bank did not insist on strict compliance with the provisions of Clause 5. So it couldn't retrieve the situation by making the clause do double duty as an assignment. The Court of Appeal acknowledged the force of this argument in relation to the interest of the policy, but it held that the concluding words, the bank alone shall have the power to settle, compromise, and recover any claim against any insurance company, were not restricted to claims on policies effected in the name of the bank in accordance with the first part of the clause. So they operated to assign an interest in the proceeds of any claim on any policy of the mortgage property. And so what they end up happening was arguing back and forth that in essence, the insurance company was to pay the bank.
Mhm. They had,
That's basically what happened. The insurance company was to pay the bank because they were trying to, I guess, get away from the fact of it. They did give them notice in writing, which is what they were supposed to do, and they acknowledged it. So since the policy was in the name of Mr. Whitehall, the bank could, for the reasons explained, only have obtain an interest in insurance as assignee. CMG was treating the request as notice of assignment, and their lordships, in the context of a notice to an insurance company by mortgage, the language was plain, and they advising Her Majesty that the appeal should be dismissed and the appellant must pay the bank's costs before their lordship's board.
yeah, so the insurance company had to pay.
Yes, ma'am.
Everybody understand that, right? So you see, even banks have their liability when you read the mortgage deed. Those clauses are not put there just for putting sake. The bank put all those things, those clauses in there to protect its interest. Any questions on that one?
No, that was clear. Because
Yeah.
if they had not sent, they recognized that there could be a problem, and that's when they sent the letter to ask them to clearly state their assignment. If they had
Yeah.
not done that, then they would have lost.
Mm-hmm. Correct. All right. RBC and Lawson Hall.
Good night. Okay. This is a case in the Supreme Court between RBC and Lawson Hall. This is only the decision by Jay Winder.
Mhm.
And he stated, this is his brief decision on the application of the first defendant, which is Lawson Hall. Pursuant to Order 18, Rule 19 of the Rules of the Supreme Court to strike out or stay the proceedings in this action. The second defendant, who is Rhonda Hall, supports the application and adopts his submissions. So the defendant's challenge to the action was centered on a breach of Section 4(1) of the Homeowners Protection Act and Section 4(3) of the Homeowners Protection Act provides obligation of mortgagee to give notice prior to institution court proceedings. Where a mortgagee is in breach of the mortgage agreement, the mortgagee shall not institute proceedings before the court in respect of the breach unless there has been served upon the mortgagor, either personally or by registered post, at least 30 days prior to instituting such proceedings, a notice in writing stating the nature of the breach of any covenant in the mortgage. The court may, as it see fit, upon an ex parte application by a mortgagee, vary the method of service mentioned in subsection 1.
Okay, so remember last class, the question was raised about this personally or by registered post.
Yes.
Okay, and I told you all I have the case. And this is it.
Okay. So the plaintiff's evidence, as contained in the affidavit of Neil Roll, filed November 20th, 2020, was that they wrote to both defendants notifying them of their breach under the mortgage. If breach not satisfied, proceedings would be started without further notice. Their right to apply for relief and means of contact of the plaintiff to discuss matter in compliance with the Homeowners Protection Act. The letters were served by registered post to a general delivery address. Receipt of that was exhibited in the affidavit by Neil Roll. The plaintiff relies on the provisions of the Interpretation and General Clauses Act to support their position that they served the notice required by virtue of the Homeowners Protection Act. Section 7 of the Interpretation and General Clauses Act provides where any written law authorizes or requires any documents to be served or any notice to be given by post or registered post, whether the expression serve or give or send or any other expression is used, the service or notice shall be deemed to be affected by properly addressing, prepaying the postage thereon, and dispatching by post or by registered post, as the case may be, to the last known postal address or to the post office box number of the person to be served or given notice, or in care of the post office for general delivery. An envelope containing the document or notice, and unless the contrary is proved, such service or notice shall be deemed to have been affected 96 hours after the time of posting of the envelope. The evidence of the second,
Hold on, I want all of you all to take note of that. Now you know what it means now, right?
yes,
In law. Go ahead.
the evidence of the second defendant in her affidavit is very instructive and speaks to the vagueness of the purported service by post. She says she was not served with a demand letter in accordance with Section 4 of the Homeowners Protection Act. She have never seen the letter from Higgs and Johnson, nor any demand letter from the plaintiff by post or otherwise as described in the affidavit by Nia Rule, prior to same being included in the plaintiff's affidavit. The affidavit stated that she was served at her last known address, but was instead addressed to general delivery without specifying the post office, even though the plaintiff was well aware of her last known address, as it was on the summons. She could not have received the letter because no address or PO box was listed on the demand letter, nor the registered post receipt. Just Rhonda Hall, general delivery. She said she believed that this was intentionally done to ensure that she did not get it.
Go ahead.
Whilst it is true that the Homeowners Protection Act permits service either personally or by registered post, there must be a proper registered posting of the notice. There is no evidence as to how and why RBC would determine to send a letter to the defendants at a general delivery post box when they were well aware that the defendants resided in premises which are the subject of the mortgage at Swordfish Drive, Stapleton Gardens. There is no evidence as to the basis it determined that this was the defendant's last known postal address, and more importantly, which post office location this was. In any event, on the second defendant's evidence, the plaintiff was aware of her postal address. Reliance upon the Homeowners Protection Act and the IGCA is premised upon the use of a proper postal address. The judge found that the service purported to have been made pursuant to the Homeowners Protection Act on defendants were inadequate, in the result that the plaintiff did not fulfill its obligation under the Homeowners Protection Act. He did not accept that there was service by post on these defendants. As the defendants note, when it was time to pursue these proceedings in the Supreme Court, there was no difficulty in seeking to effect personal service on them. Their address is prominently stated on the originating summons as Swordfish Drive, Stapleton Gardens. The purpose of the Homeowners Protection Act legislation was to provide meaningful protection to homeowners by ensuring a true and proper discourse between the mortgagor and the mortgagee, prior to taking the significant and ultimate step of recovering the security through litigation. Its provisions ought to be strictly complied with, otherwise mortgagees would be precluded from instituting proceedings. In the circumstances, he was not satisfied that there has been compliance with the Homeowners Protection Act, in the result that the plaintiff is prohibited from instituting proceedings without complying with Section 4.3 of the Homeowners Protection Act. The action was struck out. The plaintiff was free to commence fresh proceedings, which comply with Section 4.3 of the Homeowners Protection Act.
Okay, so now this is one of the first cases that was tried in court on the Homeowners Protection Act. In the Tribune, it started by saying RBC bungled its bid to initiate legal proceedings to realize its mortgage security on a couple's home by failing to comply with the HPA. Because remember you started asking questions about the HPA, and I told you to put in place to protect the homeowners. And there are steps, as when you read the act from the beginning to the end, you'll see there are steps. There are days, there are things that need to be done by the bank and by the borrower to meet the requirements. So let's go to module 6 before you all fall asleep.
I have a question before we get to module 6, and same thing you were discussing, Homeowners Protection Act. Sorry, can I ask a question?
Go ahead.
I'm awake. What if a step is missed? For instance, if the bank found out, because this matter to go to the attorney, and the attorney would have reviewed the documentation and whatever the case may have been. What if at that stage, they found prior to getting to court that they missed a step? Would they have to start over?
Yes, ma'am. Because the steps go concurrently.
But okay, when we look at our mailing system, right?
Mhm.
We send mail to be recorded. You can send mail to be recorded. What if you don't get a receipt? How do you rectify a situation where in fact you know you did A, B, C, and D? How do you fight that in court? Because you know for a fact we have I don't say bungled, is that the right word? Things can happen.
Mhm.
Don't the bank have some grounds, or wouldn't that be used to say that can be a defense to some degree?
Yeah, but okay, when you keep saying, when you send a letter to the post,
Uh-huh.
To- registered post, you always get a receipt. What do you mean you don't get? a receipt?
Okay, let me talk from my experience. The way I understand it, it's done.
Uh-huh.
It is sent to the mail, the messenger takes it to the bank, take it to the post office. It's
Mhm.
left there
They get a
And the-
receipt.
to come back for a receipt. They don't get a receipt right away. And the receipts take a while for them to be ready and prepared. So if they take something today to the post office, they can't go tomorrow and say, I come for my receipt.
Okay,
It's
so
never
let's say
ready.
in 2 days.
Sorry?
So let's say they go back in 2 days.
No, not 2 days.
What, 3?
To be honest, I've seen situation now. I'm not saying I'm trusting the messenger, right?
Mm-hmm.
It takes more than a week, and in some case more than say 2 weeks, because you'll send him and he'll go in and they tell him come back, and it'll be a long period in between before you actually get a receipt. And he's saying it's the post office. So isn't there some not jurisdiction? Shouldn't there be some recourse for the banks when it comes to our mailing system? We don't
Okay.
have the best system in place.
Right, but listen to what the IGCA says. They say the service on notice shall deem to be effected by properly addressing, that's the most important thing, properly addressing, prepaying the postage thereon. Isn't that what the messenger does?
He doesn't prepay. I think they have an accounting system. So he delivers, and the post office does whatever it needs to do to register it. And from what I understand, they bill the company or something of that sort. So the messenger doesn't go there with the registered mail and cash in hand or check in hand. No, he leaves it for the post office to do what they need to do and to record what needs to be recorded. And he goes back and collects at a later date.
Well, the 96 hours don't begin until after he has collected that receipt.
But now the question is, how do you fight that? Because he
But
can go
that's
back within the 96 hours and still don't get the receipt.
Right, but okay, so an issue like this, because this act came into force, and an issue like this affects the bank in terms of exercising its power of sale, if this is an issue that is material to the bank being able to realize the security, then this is a matter that should be brought to the attention of the central bank, its regulator.
Okay.
Then the central bank in turn would then speak to the ministry responsible. They'll go to the Ministry of Finance to speak to whoever is responsible for that process. And then they would arrange a meeting to make sure that this is the whole process expedited more quickly in order to effect what needs to be done since
Okay.
of the legislation.
Okay, thank
But if
you.
Right, but if no one bothers to bring this matter to the attention of the regulators, it will not be addressed.
Okay,
Yeah,
thank
so,
you.
right, so a messenger complaining about it won't solve the problem. You have to take it higher up.
Okay.
Yeah.
Thank you.
Okay. So if you want to, that's how you could address that matter. When the managing director meets with the governor, which I think is every 2 weeks on a Friday, they can raise the matter.
Ms. Audra, in reference to this case, I'm thinking that, just as they're saying, they did not follow the process properly. Because if you are putting in your claim against, for the sale of the property, you know exactly where they're located. You can send a demand letter at the time of this proceeding now directly to them at that Swordfish address, but all of the other times you couldn't direct it directly to them. There are many post office in Nassau. Which one would it be at general delivery? That is too vague. You
General
have their address.
Right, the general delivery is the main post office and is put under, that would be put under the letter, what the last name is, Hall. That would have been H. And they have their own post office box, which is at the main post office. So when they go, they'll only go to 8249. They will not go to general delivery.
Right, so as she is saying, it's like you didn't want us to really get it in time.
Yes. And then it raises a suspicion
Yes.
because you know we're in the house. So why didn't you deliver it at the house? And
Yeah,
then
directly to the house.
right. And at the same time, you could have sent one to N8249. But they didn't do it.
Okay.
Because general delivery means that you have to personally go to the main post office and say, I am checking to see if there's any mail here in the name of Rhonda Hall.
Right. There was no need for that because they had a PO box.
Exactly.
Okay.
Then they should have done
Okay.
that. Yep.
So they just get to start all over again.
Yes, me. They're found to be bungling. Bungling. Okay, so what time is it now? 8:08. All right, the mortgagees, duties, and rights. Let's see if we can go through this quickly. So we know a bank is a financial institution. And as a financial institution and a bank, it falls under common law. So a bank has its customers. And once you open an account with a bank or you enter in a transaction with the bank, of course, you become a client. That's the banker-customer relationship. And that relationship is a contractual one. So when you deposit your funds, you become what? The debtor or the creditor? When you deposit your funds with the bank, you become the creditor, the bank becomes debtor. Right. Because on the balance sheet, your deposits are on the liability side. The bank owes you that sum of money. So in banking and banking law, there are express and implied terms. And a lot of the terms of what you do have now been written into the terms and conditions that you would give the customers in the contracts. But most of those terms and conditions were founded in the case of Jahimson versus Swiss Bank Corporation. And in that, it set out the general duties of a banker to its customer and a customer to its bank. So always remember that the bank itself is held at a very high standard. And because it is a contract between itself and its customer, it's expected that it will carry out its duties with the experience and the skill and the knowledge that is expected of bankers. And that's why you see people will sue the bank if the bank is negligent, if the bank misrepresent facts, if there is a breach of contract. So the bank has a duty of care in tort, because it can be sued, for negligence, for giving advice to people that they rely on. So that's why they always say staff should be very careful when they give advice to customers, because if the customer rely on that advice and they incur a loss, they can sue the bank. Always remember too, that between the bank and its customer, a fiduciary duty arises. There's a relationship. And when you see that word fiduciary in common law, that means that there is loyalty, that there is confidence and trust. And that's why you see everything to do in banking, in securities, it is based on trust and confidence and loyalty. And that's why the duty of confidentiality is so strict. So when it comes to confidentiality, there are only 4 cases that you can disclose a client's information. One has to be compulsion of law, such as when you get a request from the Attorney General's office or from the police, or on the opposite side, when an MLRO would file an STR. The second is when it's in the public's interest. The financial institution can file a matter that may amount to a breach of confidentiality. The third is when it's in the bank's own interest, which means that the bank has detected something and they decide that they need to disclose that. They can. Such as when they voluntarily disclose that they suspect there is a fraud. And the fourth is with the customer's express or implied consent. And that's been a long journey, but most of the common law implied consent that was established in the case of Joachimson versus Swiss, and in Martin, Woods versus Martin's Bank, they've all been more or less enshrined now in the terms and conditions that the bank would issue to its customer. So a bank is also required to provide a statement to its customer periodically, although the customer is not obliged to check the bank statement for errors. And now you know over time now, the banks have included a provision in its terms and condition that the customer should check. And if they see an error, they give you a time period in order to report it. So what are these general rights of a bank? One is to charge the customer a reasonable commission for services. And notice it says reasonable, and that's why you see the bank, under the Banks and Trust Companies Regulation Act, they will act, it's required by banks to advertise and advise when they are changing their fees for services. It's the right of the bank to demand repayment of any loan. It's the right of the bank to exercise any lien over any securities that are deposited with the bank. It's the right of the bank to be indemnified by the customer for any expenses or liabilities. if they act on behalf of the customer, which means that they're acting as an agent. And is also the right of the bank to return any unpaid check. Because don't forget now, when you present an unpaid check or there's insufficient funds, you're asking the bank for an overdraft, which is a loan. It is a right of the bank to exercise the right of set off, which is the right under certain circumstances. And of course, the last right of the bank is to combine accounts. So even though the bank has right, the customer and duties, the customer has the duty itself. The customer has to pay the charges. And notice they use the word reasonable. That means that a customer, if they want to close their account, they can't go to someone else if they think the fees are more reasonable. The customers have a duty to issue checks only if sufficient funds are available. And the customers have a duty to exercise reasonable care in drawing checks. Now remember, the central bank is already on its move to eliminate checks as we move more towards digital currencies. And of course, the last duty of a customer is to advise the bank of any known forgeries. The rights of a customer is to repay funds deposited on demand. The right to have the bank discharge its duties to them. And of course, the right to have their funds deposited appropriate to the respective accounts. So let's look at the specific rights of the bank as a mortgagee. First is the right to possession. A legal mortgagee is entitled to possession of property as soon as security over the property has been executed, and even though there has been no default on the mortgage loan. Remember that a court order is required to enter into possession. If the mortgagor is in occupation of the property, and in some cases where the mortgagor refuses to leave, an eviction order is also required. And the cost of entering into possession is borne by the mortgagee. So banks are reluctant to go into possession due to the inconvenience administratively and the potential liability for any negligence, which may cause damage to the property, and also the strict duty to account for any profits and rents. The bank has a discretion to adjourn proceedings for possession of mortgage property, particularly in the exercise of the power of sale. Under the terms of the mortgage, where there appears to be some likelihood that the mortgagor is able to pay any sums or the whole of the sums due and owing on the mortgage, or to remedy any default within a reasonable time. The second right of the bank is we'll talk about the right to statutory and contractual power of sale. The mortgagee has both a statutory right under the Conveyancing and Law of Property Act and a contractual right under the indenture of mortgage to sell the mortgage property in the event that the borrower defaults on the mortgage. And they do so under the terms of the mortgage. The mortgagee may sell the mortgage property in whole or in part, and such sale may take place by auction or private contract. Although the statutory power of sale arises when the mortgage money becomes due, it cannot be exercised until one of the following conditions have been met. Demand for payment, followed by the default continuing for 3 consecutive months, or interest remaining in arrears for 2 months, or breach of some covenant. The right to additional property. Since the mortgage of land includes fixtures and anything subsequently affixed to the mortgage property, after the security has been executed, the legal mortgagee is entitled to the additional chattel. That is, the furniture and the fixtures. The right of title. The first legal mortgagee is entitled to all the title deeds though the mortgagor may inspect and make copies of them at his own expense. An equitable mortgagee is not entitled to the title documents unless this is stipulated in the equitable mortgage agreement. The right to protect the property. Most mortgages contain terms regarding the borrower's obligation to maintain and insure the mortgage property. However, the mortgagee has a statutory and a common law duty and the power to prevent deliberate damage, carry out necessary repairs, and insure against fire. It should be noted that if the mortgagee goes into possession of mortgage property to carry out repairs, it must account strictly for the work done. Additionally, the right to insure against fire is only to the extent of 2/3 of the reinstatement value and does not cover other risks. The right to tack. The mortgagee, as a secured lender, has the right to add further monies to the security so that the monies are also secured. And that's a provision that they started putting in the mortgage deeds in the last 15 to 20 years, that right to tack. The right to appoint a receiver. A mortgagee may appoint a receiver under the terms of the mortgage to collect rents from tenants on behalf of the mortgagor or as his agent. And then the right to consolidate. The bank may consolidate mortgages, although banks take all monies mortgages, which eliminates the need for separate mortgages. So if you look at a recent mortgage deed, you'll see they have the all monies clause. Investment advice. With regard to lending and generally, when a bank gives investment advice or lending advice, it owes a contractual duty. And there's a torturous duty to take reasonable care in the advice that you give client because you can be sued. The duty to take reasonable care in providing advice is more pronounced in instances where the banker advertently and personally assumes the responsibility of giving or volunteering investment advice. And the customer reasonably relies on the statements made by the officer of the bank. Where the ordinary business of the bank does not include providing advice on the viability or prudence of residential and commercial projects for which the bank is lending money, the customer must make it clear to the bank that its advice is being sought and not make a mere request for a loan. In order for the bank to be under duty of care to the borrower and potentially liable for negligent advice. Banks must be prudent and aware that in merely providing information to the customer, they are still under a duty of care to ensure that the information provided is accurate. So this legal principle is particularly important since statements made by bank officers who have actual or apparent authority to make such statements in the contrary course of the bank's services without any effective disclaimer and upon which a customer may reasonably be expected to rely will attract legal liability, especially if they're made without reasonable care. And a bank may also be held liable for contributory negligence in lending cases to other professionals like appraisers and attorneys whose advice has supported lending which caused loss to the mortgagee. So exercise of a power of sale. The mortgagee has a limited or equitable duty to the mortgagor and any guarantor of the mortgage's debt to take reasonable care to obtain the true market value of the property at the date on which it decides to sell. The mortgagee does not have a duty to take any action to preserve the value of the security in the exercise of its security rights ahead of obtaining possession and control of the property subject to the mortgage. The bank does have a duty to account for the proceeds of sale of the mortgage property, since it is a trustee for such proceeds for the beneficial interest of the mortgagor. It must pay the mortgagor any surplus of the proceeds of sale after the outstanding mortgage principal, interest, and all the bank expenses and costs associated with the sale of mortgage property have been paid. So of course, you know, when the bank is exercising its power of sale and acts as the vendor of mortgage property, it conveys the mortgage property to the prospective purchaser, subject to such right and equity of redemption as is subsisting in the property by virtue of the mortgage deed. So the mortgage property to be sold under power of sale, it should be noted that while there may be no commercial obligation by the mortgagee to pay the outstanding real property taxes on the mortgage property or incur the legal and administrative costs in the exercise of the power of sale, the outstanding real property taxes represents a first charge on the mortgage property. And then you could read the section on real property tax. So let's look at liabilities of a mortgagee. First liability is undue influence. Undue influence is an equitable term, and it is where contracts or gifts which are made or given on the premise that one party has obtained a benefit by reason of the exercise of influence over another person who is manifestly disadvantageous to the other person. So you see this sometimes when husband and wives come in for a loan, and you have to look and see whether or not one of the party is influencing the other one in order to enter into that arrangement. Undue influence is normally based upon and carried out in the context of a special relationship where trust and confidence exists. Familial romantic obligation may underscore the relationship. That could be doctor and patient, attorney and client, husband and wife, parent and child, banker and customer. Banks should be particularly aware of the concept of undue influence, as a third party, spouse, parent, or child may grant a guarantee or other security to it over the family home to support the borrowing of the contracting party, of the primary borrower of the bank. If the primary borrower defaults and the bank commences proceedings for possession and exercise of the power of sale, the guarantor may allege that there was some undue influence, either wielded by the primary borrower over the guarantor, or they could say undue influence by the bank itself. So to mitigate the risk of undue influence by the bank and by borrowers, the guidelines in the case of Barclays Bank versus O'Brien are instructive to banks with regard to advising the surety to seek independent legal advice before agreeing to act as surety or guarantor or distinguishing relationship, which may have undue influence existing and acting accordingly. The next one is mistake. A mistake will not affect the validity of a banker-customer contract unless there is a serious mistake of fact. A mistake may be made as to the subject matter of the contract, the signing of written documents, and the identity of the parties. Where a mistake is proven to have occurred, the contract is considered void. In order for a bank to recover money paid by mistake, certain conditions must be satisfied. The bank pays a customer's money to another person under mistake of fact, having believed the signature was genuine, or having believed that a payment had not been stopped. There is no requirement to prove that the bank was negligent in paying the amount, only that it had been mistaken in doing so. The bank pays without the customer's consent, particularly where there are insufficient funds, believing that there are sufficient funds to cover payment, or pays a stop check, believing no countermand is in place. The bank pays a check and later attempts to recover the funds, but does not act with great speed. However, a bank may not be able to recover funds where A, it made a representation to the payee that it was making the payment, and the payee changed his position in good faith to its detriment as a result of receiving payment, or it paid another bank as a collecting agent for the payee, and the payee has withdrawn the funds. The paying bank can only collect from the payee, not the collecting bank. However, the collecting bank must have no notice of the mistake before the funds are withdrawn and have acted in good faith. So where a bank has mistakenly credited a customer's account, it may re-debit the account or reclaim any funds which the customer has withdrawn from the account. However, the bank may be stopped from recovering the funds if the customer changes his position in good faith as a result of the credits being mistakenly deposited to their account. Misrepresentation. This is a false statement of material fact made by a party to a contract or his agent, which induces the other party to enter into a contract. And misrepresentation can be innocent, it can be negligent, or it can be fraudulent. The parties to a banker customer contract may rescind the contract where any of the foregoing types of misrepresentation exist. Damages are available for fraudulent misrepresentation under the tort of deceit. And then you have negligence. And negligence is a tort. And I mentioned negligence before, because remember, in the banker customer relationship, there is a duty of care. And the bank has to ensure, because it is a bank, is expected to have that higher experience and skill and care in exercising all of its duties that it carries out. So banks must be careful to avoid negligence by making negligent misstatements. For example, where there is a special relationship between the parties and one of the parties relied on the particular skill of the other party and suffered some loss, and that other party knew of this reliance. And of course, you have professional negligence. For example, financial advice or information is given to a third party. You want me to do the duties now of the bank under the homeowner's protection, or leave that for Monday? Hello?
I have no problem, but I don't know if anybody else, 'cause I see the time, so it's
I
up
see
to
the-
the rest of the class.
I have no issue.
Go ahead. It seems so.
I guess we almost there.
Yeah, we almost there. We almost there. But I mean, the next chapter is kind of short. Module 7, understanding the mortgage process.
Okay, let's wait till we do 7 then, since it's short.
Yeah, 7 is short.
Are we having cases?
Of course. Don't worry, cases soon end, and then you're gonna be bored. And then you're gonna be asking me, oh, why aren't there any more cases? So yes, I have more cases to send.
When is midterm again?
We'll be back to that again. It's not now,
It's
Oh, I
so
might have
near.
missed it.
We need
August
I
our
might
group.
have missed it.
17th. Next week, Wednesday.
That's close to I know. That's right there. Okay.
That's only
Because I
around.
tell you, there's no review time. These cases just take up all your time.
What? No. The cases is final exam. We had agreed.
Mm,
We had agreed. The only case you might see is the case of Sylvan.
what a long one. Okay.
The long one. Only Sylvan you may see. That's it. Because that one is very important on receivers. Okay, so if you haven't read the Homeowners Protection Act, please do. You need to read it.
It did.
So what I will do is we will go read the mortgagees, duties and liabilities. And then I want us just to go through the act to see the process. And then we will do unit 7. So I may not send you too many cases. I'll see. But someone owes me a case next class, Dora May. BOB versus the Maycox.
Yes, ma'am.
Okay, so we'll start with you first. And then I'll see what other cases I have. I think I'll send you some with the bank having to correct the figures. So you can see how that impacts mortgages, where people making their, suing the bank, or the bank is exercising their power of sale. The issues that come before the court. So I may extend a few of those. I'll try and see if I could do it tomorrow, but I'll tell you what the issue is. When I find these cases, they're at the point of time when they issue it. So when I go back to the website, sometimes the cases are gone. They're no longer uploaded and I can't find it. And so it takes me quite a while to find them because mine is already written up. So I'll try and see what I can find quickly so I can send it to you all tomorrow. Okay?
Ma'am.
And I'll just make a reminder, don't forget to read the Homeowners Protection Act. And make sure you study for your tests. All that's
1 through 4, right?
yes.
Okay.
To ask Demetria.
Chapters 1 through 4.
Oh,
Mhm.
it's for the
I
test?
thought it was 1 through 6.
No. Y'all came back and you changed that.
She had mentioned 1 through 4 last week. She was gonna put 5 and 6 on the test.
Right, because remember, you didn't want scenarios. You only want multiple choice.
Yes, ma'am.
Right.
How many
And 5,
questions we have, Miss Archer?
I haven't finished it yet. I'm out almost to 40.
Gotta go. Okay.
Almost to 40. So if I could get to 50, then y'all will be straight.
Yes, ma'am, we would.
Yeah. So I'm trying to make them very easy. Tell me about it afterwards. All right?
We will.
All right, so I think you have an idea how my brain works now, so get prepared. And remember, multiple choice is always what's the best answer. Be mindful. I think I put that in instructions. Because you'll see more than one answer that may appear to be right, but what is the best answer to what I'm asking? How that sounds?
So Sally, this can be
It sounds
tricky.
like a setup. That's what it sounds like.
It is not. Seriously, it is not. Well,
You
have-
just saying it looked like an A and it looked like it could be C, and yeah, I don't see this could be a problem.
this I could be a problem, and you ask for multiple choice. I was
Okay,
pushing
Miss
you
Archer.
and see, you all say multiple choice.
But not to trick us with the multiple choice.
Miss Archie, you
Yeah.
say it's gonna, you was making this as easy as possible.
These are not difficult. Tell me
Okay.
about it. And then you could let me know. Sound like I
Sound like
have
you need to give us an example.
a what?
An example of what you're talking about.
Let me see if I have my draft. I could give you one question. Let's see. I could close my eye and point my finger without reading it. Let's see. Oh, the all people was just ready to go to your bed. Now you all want to bother me with questions. Let's see. All right. I think I went on one. A permanent right of way over a neighbor's land is A, 1, legal estate, 2, freehold estate, 3, legal interest, 4, legal right. What? Who laughing?
You said a permanent right of way.
Over a neighbor's land is A, 1, legal estate, freehold estate, legal interest, legal right.
What the first one was again? Because I'm thinking legal right, but what the first one was again?
Legal estate, freehold estate, legal interest, legal right.
It's a legal interest.
C, legal interest.
Yes, it is.
Oh, hallelujah. Okay.
So I tell you, it's not hard. You just have to think.
Yeah, because it's over the neighbor land.
Mhm,
It's, yeah, it's the right of way.
mhm.
So, yeah, it's a legal right.
No,
Legal interest, sorry, legal interest. It's the interest.
so at least you get one right so far.
Yeah, it's still an
At least
F,
I
but
get
okay.
1 point. I can be looking diligently for that question.
At least you get one. You get one. So that's all. You just have to think a little. Like I say, you need to select the best answer. Because they're
So
gonna
if I
be
was to,
close.
if I was to
but
say D, a legal right, that would be absolutely wrong, or you get half a point.
it's wrong. There's no half.
Oh, Lord, you say the best answer, you know, that means there's more than one answer.
Yes, but that's not the best one. Choose the best answer. The best. Or should I say choose the correct answer? No, choose the best answer.
Because I just sound like we could be having court when time to mark this paper.
No, that's for the
To
exam.
make sure it could be arguing on what she thought was the best answer.
Exactly. What's best for you may not be best for me.
Then, but I taking these from the
Thank
book.
you all.
I give you one more and then go to your bed and try to figure out how you going to study. Okay, let me give you a little easy one. Oh, okay, easy one. The deposit upon the exchange of contracts is usually A, 20%, B, 25%, C, 10%, D, 15%.
C.
Correct. See how easy that is?
Good night, everyone.
What you said, Demetria? D?
C.
Huh?
It was C again. C.
Oh, C.
10%. C, yeah.
Okay, good night.
Good night. See? It's not hard.
Okay.
It's the best answer.
Yeah, that's the best answer.
Okay. Fret not, and don't curse me.
No, Mom.
All right. So,
All right, good night.
Miss Archer. Good night.
go ahead.
No, I
Good
don't.
night.
Such thing.